So as a real estate agent, I regularly get phone calls from people claiming that somebody's being cheated, and oftentimes because they're elderly. Not that I see it sometimes. I see, to me, cases that are clear of somebody attempting to or fraudulently stealing from people who are elderly and maybe not able to defend themselves. Really excited today to share an elder law financial fraud litigation attorney, Ingrid Evans, who's in California, both in Northern and Southern California. Ingrid, thank you so much for joining us today.
Sure, no problem. Yeah, I get lots and lots of calls every day of elder financial abuse, and I handle all types of elder financial abuse cases across the state. It's really sad what's going on.
I was saying, on one hand, it must be great. Businesses, people call you all the time about somebody stealing some grandma's money. On the other hand, that's a bad thing, and I don't see that slowing down. I don't see anything to me indicating that we've got our arms around this or we're protecting people better. The opposite. It just seems that criminals find new creative ways to dig in than ever before. So let's talk about what's the most common case that you see that you would say is actual as opposed to alleged, that you look at and say, this is a pattern I see increasingly now of elder law abuse, financial scams of some sort.
There's a bunch that I see regularly, but I would say the primary one is the caregiver that comes in. No relation with the family, no relation with the elder. The elder's isolated. Maybe they have no family. Maybe their family is in another state. Caregiver comes in and deeds property to themselves or change the trust and will because they can unduly influence the elder, or they've got dementia, or they have one of these quitclaim deeds that they can just have them sign and they have no idea what they're signing. Sometimes they don't even speak English or they can't see what they're signing. So the whole gamut, but caregiver fraud is, I would say, the primary area, but I also deal a lot with annuities and reverse mortgages that are sold to elders. And so those tend to be a big problem as well.
Now, the last part, that was very common. Reverse mortgages, I would say, was in the prior phase. I want to say like in the 2000s or so, it was almost always reverse mortgage, funding an annuity. So you had some mortgage broker getting a real estate commission and then a annuity commission was like 10% of the money invested. I thought that was restricted. Is that still going on?
It's illegal, but I do see it still. So I do see a lot of reverse mortgages where people have their money taken out in a lump sum, and then that's used for various practices. Yeah, so annuities, we see a lot of repairs to their property, which with contractors that aren't on the up and up, that charge them way more than they should be charging. A lot of solar scams. I see a lot of that.
Wow. You talk about the deed, and I see that very regularly where there's a wild deed of some sort. I had a case recently where on a real estate deal, the family came to me and it was obvious that the deed quit claiming to the caregiver was invalid because it was done after the date of death of the decedent. And so we had a death cert, and then we had the certification at the consulate in Mexico, and the dates were the dates, and they just didn't work out. Sorry, not sorry, the title company. And it was interesting because I'm sure you see this too. There's what's legal, and we can prove in a court of law, and then there's what a title company may or may not accept. And so sometimes you could say as an attorney, well, that deed doesn't have any standing, but good luck selling your house with it there. Or this deed will solve the problem, but the title company may not accept it as is and come back to you. So how do you kind of reconcile those two challenges?
Well, most of the cases I've been dealing with are either flat out forgeries of the deed, or they have the elder actually sign. So really the title company doesn't have any involvement at all, and they sign off on it. And so we're lucky if we can stop the sale of the property. We will file a lis pendens if we catch it in time, like we've done on one case I'm handling right now. But 2 other properties from this elder were just forged and sold. And the wrongdoer took the money and ran.
So in those cases, the person sold it, there was title insurance. The title insurance company insured a transaction based on a deed that was forged. Does insurance cover the person who had the property stolen from them, or is there a claim against the title company, or is that as long as the buyer is good, they don't care, or how does that work?
We don't usually go against the title insurance companies. We usually go against the wrongdoer and then try to get the money back from them. If we have to, we can go against the title insurance companies, but it's got to be pretty, it's got to be pretty obvious that it's forged. And usually the majority of situations I see are where the caregiver just has them sign something because they trust them.
Right.
So in that situation, title insurance doesn't come in at all because
Right.
they're signing off on it.
Right. The ones that are forged and obvious forges, I see that more commonly in the 2008 and 9, where there's so many transactions done. They're just being recording everything and then insuring it. And that became a problem. I think you're right. Lately, it's so easy and so common knowledge to forge. I'm sorry, to get the elder to sign the documents falsely under duress. So the obvious question then is, because I've had this happen all the time to me where, daughter, son says, oh, it's under duress. Well, maybe it is, maybe it's not. I mean, there must be cases where people develop personal relations with a caregiver. Unfortunately, in some cases, the caregiver has more of a personal relationship than the kids. Is it always a case that the caregiver is at fault when they did that? Are there cases where you look at that yourself and say, you've been talking to them for 10 years, what do you expect? How do you resolve that?
Yeah, sometimes you'll look at a case and you think, oh, well, maybe they did have a relationship. Like we've had situations where the caregiver has been involved in the elder's life for 30 years, and that's something you need to take a look at. But what I always look at is the history. So if they have an estate plan that has always given their property to their one child, and that's never been changed, and suddenly when on their 103rd birthday on the brink of death, it's changed to the caregiver, we have a problem there. Also, usually the house is just kind of the biggest asset, but if you dig deep into the bank account statements, you'll find that they're helping themselves to money as well. And so I'll see forged checks and cash taken out. And so there's just a pattern in practice that you kind of look for to determine what they're doing.
We've dodged a couple bullets. My mother-in-law had a caregiver that was writing herself checks for her service, and it was supposed to be, I think, twice a month, and she was writing one every week. And because my mother-in-law didn't remember when the last check was, and so she basically was doubling. We caught her, and she agreed to pay us back, and we really dodged a bullet with that one. And we all had another caregiver where living with an aunt who, I kept watching and watching, and nothing was going wrong, and nothing did go wrong, except for at the end, she was like making a claim to me that she was owed money. And I thought, it's that kind of sense of entitlement that leads somebody who's desperate financially to commit a crime. And so I know for me, I was checking title every 30 days just to see if there was a deed out there. So what are things that you can do to protect your family members? Obviously, protecting them is also maybe cheating them by the other family members. But what do you think are best practices to protect the elderly family members? You can have a plan, but like you say, the plan could be deeded out of easily enough. So what do you recommend as protections?
So a bunch of things. So first and foremost, never give a caregiver access to a power of attorney for either advanced healthcare directive or for finances, and especially finances. So having them write a check to themselves every week or every 2 weeks, that's a mistake in and of itself. You should never give the caregiver access to a checkbook, cash, finances in any regard. They should not be helping them. You should have a private fiduciary for that, or somebody who's licensed and bonded, or a family member that's trusted to help with your finances. Number one. Okay. Number two, I also think people set up their estate plans incorrectly, and I'm not an estate planning attorney, but what I have learned from my own issues, the cases I've been handling, is you don't necessarily want everything going to your spouse in full. Okay. And that's the way typically people set things up. So they have you pass away, it goes to your husband or wife, and then your kids inherit after that. So I have done it a little bit differently, so that if something happens to either me or my husband, everything goes to our kid rather than to each other. And so we just get a life estate in the community property of the other person for our lifetime, and then everything goes to our son or daughter, so that we don't have problems down the road. Because it's a lot of people end up getting dementia. They end up being taken advantage of. I've seen it in my own family. And so that is one way, if you want to protect your kids, to have it set up a different way, so that there cannot, you can still have abuse in any situation, but it's harder in that situation because they can't will or gift away anything of yours or of theirs, because it's going to your kid.
So not to make the business of law and litigation sound crass, but it is a business at the end of the day. And I know that when people come to me and pursue litigation, it's an expensive process. Like you can't,
Expensive.
there's no credit card, Visa, here's, $50 and file an online thing. You have to kind of commit to taking it to a certain point, and that certain point is expensive. How do you advise people financially on what the requirement is to begin the process? And obviously you can't predict the future depending on how the other party reacts. It can go one of numerous ways. So how do you handle that uncertainty when you talk to clients up front?
That's a tricky situation. I actually prefer contingency cases. So in a
Ooh,
lot,
interesting.
yeah, a lot of the cases I handle, the caregiver fraud cases, I will take on contingency, which a lot of lawyers will not. They do it only hourly. So I'll do it on contingency because maybe the grandkids can't afford to pay an hourly for, a $3 million property. So I'll take it on a contingency and work it that way. And I like those cases better, frankly, because I can work the cases very aggressively, issue a lot of subpoenas, but I'm funding it. So it's all on me. If we win, it's on me and how much I've done, but I'm also not charging them a huge bill every month. I do have a lot of hourly cases as well. And in those situations, I explain to people, look, we can try to settle this before litigation, but this person, and if you think they're going to be litigious, we're not going to be able to settle it. And we're going to have to go straight to litigation and filing a petition or a complaint. And in that situation, I explain, look, the initial complaint or petition could be, at least $10,000 sometimes. And then getting into actual litigation, contested conservatorships with an elder abuse component, those can be upwards of $100,000 easily. So, I feel bad for people that end up in that situation, but I definitely tell people what they're getting into so they know what they're up against.
Well, you're one of the very few that I know kind of put out that you do contingency. I know that there are others that do it or maybe blend it, like they'll start with some cash and then one of the attorneys I interviewed who had a large settlement in Orange County started cash and the customer was into it for $250,000 and they just ran out of money, and the attorney said, well, we can go forward, and he was able to work something out that worked out for everybody because it is very expensive to fund. So it's good to know that you at least will entertain that. And it seems to me, I usually tell people it's going to cost you probably at least $100,000 if it's litigious. The client should know better than you, right? They're talking about the caregiver and they're going to describe the caregiver to you, but theoretically they should be able to make the judgment. How likely is that person to be difficult? And I think sometimes they want to blame the attorney for not understanding the likelihood of the litigation, but really as a client, you have to make that decision and be responsible for it.
Yeah, I've had some cases that settle very quickly after we file a complaint, and then I have cases that drag on. And the only one who's going to know that is the type of person we're dealing with.
Right.
I don't.
Right. And you were there to see things that you described as best you can, but you were actually there, and I'm just trying to get it secondhand. So I can see where that really, the customer has to take that responsibility, but the fact that you offer that is very unique. So is most of your business coming to you from referrals from other attorneys that maybe did an estate plan, there's a problem going sideways, or has a client that's going sideways, or do you get approached by real estate agents, or what is the most common source of your business development?
Usually it's the kids that call and say mom or dad either passed away and we recently discovered that all the property's been given to this person, or it's they've got dementia and we just recently helped them and we realized that we've got a problem. So it's usually the kids, sometimes real estate agents, sometimes financial advisors, sometimes other lawyers, but I would say primarily kids.
So the consumers directly are finding you. How do you promote yourself to consumers, or how are they finding you?
I get from my website.
How about that? Evanslaw.com.
Evanslaw.com.
And is it because
or CaliforniaElderAbuse.com.
Oh, there you go. Okay, now that one makes more sense. Okay, so I got the email, but so California California. I'm gonna write that down. ElderAbuse.com.
Yeah.
Got it. Okay. Well, obviously, if you're doing Google search, that's a great one. How'd you get that domain name? Who'd you pay for that?
Years ago. I was a smart business lady.
Wow. Okay. Back when you were 12 years old, you reserved the domain name and made your career. Now, so let's just do a little background now on you. How did you, this is like a narrow niche of a niche of a niche, right?
Yeah.
Probate, and there's elder law probate, and there's litigation of financial abuse. How did you end up in this really micro niche of business?
Really kind of fell into it. I was at the city attorney's office in San Francisco, and I was working on affirmative litigation for the city to help kind of make a difference and impactful litigation. And the city attorney said to me, "Do you want to do an elder financial abuse case?" And I said, "Yeah, that sounds great." So I was given the first elder financial abuse case that the city of San Francisco brought through the public guardian's office in, I think it was 2003, 2002. And I brought that case, and it was a very, very challenging case, and I learned a lot from it, and I loved the area. And then I went out to private practice a couple of years later, and I've been doing elder financial abuse ever since. So I've been doing it for over 20 years.
Wow. And it seems, just from where I sit, this is an area of both population and the type of business, elder abuse, that's just exploding. I mean, it just seems like there's never ending.
Yeah, it's never ending. I mean, the amount of calls I get every day are too numerous for my office to take. So I send a lot of cases out. Every once in a while, I'll take a case, even though I'm too busy, just because it's such a sad story. Yeah.
Wow. Well, okay. So people who have concerns about an elder abuse case, CaliforniaElderAbuse.com is the best place. And if you go there, we have the website up, and it has the phone number on there and a form, the obligatory contact us for more information form. Is that the best way to get in touch with you, is be either the phone number or through the website evaluation form?
That's correct. Yes.
Well, fantastic. And what does it cost to start and ask some questions? Do they consult with you? Do they pay for an hour up front? How does that even begin?
We don't charge people for an initial consultation. What we do is I have 2 intake paralegals, and they will do the intake and then send the forms to me and the other attorneys in the office. Primarily me. I look at almost everyone that comes in, and I can tell very quickly based on my form and my questions whether it's a case I will consider or not. Some are just, I just can't, or the value's too low for my hourly rate or for a contingency, and I can't. So I'll refer those to a nonprofit or another lawyer I know, or geographically, maybe I don't want to go to trial down in San Diego. So I'll send it to a friend or another lawyer I know down in San Diego.
Well, San Diego's beautiful. If there's a place you're going to go for a case. When you say that to me, like, why would you not go to San Diego? Are you crazy? No, I get it. It's a business decision. It's a different court and all that. So anyhow, look, Ingrid Avian, specialist in elder law abuse litigation. And again, to my knowledge, one of the very few that is openly open to taking cases on contingency, though also does hourly. You can reach her at CaliforniaElderAbuse.com. The phone number on the website is 415-441-8669. Ingrid, thank you so much for your time. I really appreciate it.
Thank you. Have a great day.